May I add something? You see, if you have too few people to decide too many cases, you're bound to have problems. So we have to have a systematic plan for entire expansion of the judicial system. It is far from adequate. And we must be willing to spend money for this purpose. This can't be done free of charge. So unless you have a proper plan for expansion and enough money allocated for the purpose, you will not have a proper expansion with the same efficiency as we would like to have.
Madam, you spoke about dissemination of information regarding rights and laws. I was wondering whether there are special programs guided by the judiciary or the legal fraternity to have community outreach programs where this dissemination does take place. And what about the language and tenor? How does this dissemination really take place? Because we as citizens, even if we are public-spirited citizens, we get bogged down by legal terminology. So how does one grapple with that?
Programs for giving we do have some programs for this purpose. The legal aid program also includes giving people education about their rights. Then the National Human Rights Commission has a program for educating people on their legal rights and their human rights, basically. But these programs, I don't think are as widespread as they're required to be. Occasionally, you have NGOs doing this work quite effectively. I mean, they go to schools, colleges, sometimes women's groups are doing this kind of work, and so on. But we need to have a much more systematic dissemination of information. I agree with you, we need to have a better system, or a more widespread system.
Pamphlets in Marathi, Malayalam, Tamil, I have seen them being produced as, simple questions. Madha, Naura, Daru Piyon, Mala. So there is a simple step, the law for dummies, like the book.
I have an observation, you can comment on that. See, there have been cases where the Supreme Court has given its dispensation, but they have not been actually implemented by the executive. The police reform recommended by the Supreme Court is one of the classic examples. No state has gone and actually implemented police reform where you make the police appointment, am I audible?
As inaudible as the Supreme Court.
There have been cases where the Supreme Court has given its decision, but they have not been actually implemented by the executive in its full form it should be. The police reform recommendation made by the Supreme Court has not been done by any of the states today. Also, my understanding is that the Supreme Court had clearly indicated that Aadhaar should not become an impediment for a people to be able to get the benefits. But we keep seeing so many cases where people are deprived of benefits because the Aadhaar authentication failed for whatever reason. And in such cases, does Supreme Court not have a kind of a obligation to hold the executive in contempt of its own decision?
If the Supreme Court were to send all the executive officers to jail, number of jails would be inadequate to hold them. There are innumerable cases. Now anyway, on Aadhaar, the Supreme Court is yet to debate finally. What you read in the newspaper is just wishy-washy. Supreme Court will go into the basics of it and say it's either good, bad, constitutional or unconstitutional. Then all of us will say, yes, it is good or bad according to what the Supreme Court has said. All right?
So I think there are no more questions. Justice Sri Krishna to give its presidential remarks.
Sister Sujata Manohar, Brother Gokhale, Sister Nishita Matre, dear friends and students. It's always a pleasure to listen to Justice Sujata Manohar. I'll pick up a refrain from the end of her speech. She said, PIL is intended to challenge the powerful. This is a refrain which was there very much in our country much before all the English judges were born. Way back in the Brihadaranyaka Upanishad, the Brihadaranyaka Upanishad crystallizes the concept of rule of law in the terms of dharma and says, Yadetad dharmaha kshatrasya kshatram yad dharmaha ato abaliyan baliyam samashamsate. He said this dharma, this standard is something that is the king of kings, it is above the kings. It is the instrument through which even the weakest can challenge the mightiest. Now, that is now today called PIL. An ordinary citizen sitting on the footpath can go and challenge an order made by the President of India by way of an ordinance or an executive order in the court of law. That is the glory of the rule of law, to which it's necessary as an adjunct access to justice. Now, talking of access to justice, even access to justice has been considered. I think way back in the Ramayana period itself, Rama at one time tells Bharata and says, Yani mithyabhishastanam patanti ashruni bharata tani putra pashunhanti narakanchaiva gacchati. He says, a ruler who goes around falsely accusing his subjects causes them misery. They'll start crying. The tears which fall down from such innocent people on the ground, they will ruin the man. Why? Prityartha manushasataha. He is trying to govern them because of his caprice. That is not what is permitted. You have to govern them according to a rule of law. Give them justice. The third instance is, in this country, there have been good rulers. Kings have been reviled for no reason. There have been good rulers, bad rulers, good ministers, bad ministers, good judges, bad judges. Let us accept that. Now, way back, in the history of Kashmir is beautifully written by a poet known as Kalhana. His Rajatarangini is a very famous historical record of the history of the Kashmir kings. There was this king called Chandrapeda. He wanted to have a temple built for his Kul Devata Tribhuvana Swami. So as usual he calls his ministers and says, Mandir banane ka hai, jaga dhundo. You know that Mandir Masjid thing going on in those days also. So these people picked on a 10-acre plot and said, this is a very good place, let us build a huge temple here. Only difficulty was, in one corner, there was a cobbler's hut. So the ministers, fellows, hatao isko nikalo. They wanted to throw him out from there. That poor man said, I can't go anywhere, I don't have a place where I can stay. I'm staying here with my family and I'm a poor man. So he came running straight and barged into court of the king. No, not even Jahangir Badshah's Ghante Bajana. He just barged in, stood before the king and said, O king, your palace is dear to you, my hut is dear to me. If your palace is destroyed, what pain it will cause to you? If my hut is destroyed, it will cause me the same pain. Please protect me. Now if you file a PIL in the court, your lawyer will argue, government leader will argue, advocate general will argue, attorney general will argue, court will keep it pending for 6 months, and then a decision will be given 2-1, 3-2, and then again 3 judges, all kinds of problems. The king looked at him for 5 minutes, heard him for 5 minutes, and he immediately gave his judgment and said, Vinimyatam vinirmanam athava anyatranyatam. He says, stop the construction or go and do your construction elsewhere. Why? He says, I am charged with administering justice. If I am causing injustice to human beings in my country or to my subjects, I am unworthy of being the ruler. He says, stop this. That is access to justice. The day when we can have access to justice like this, a la Chandrapeda or a la King Jahangir Badshah, then the problem that was raised by this gentleman here would have been solved. But there is always a gap betwixt the dreams that you have and what you say as ground reality. In ground reality, there are innumerable difficulties that are to be faced. First difficulty is what Mr. Pradhan pointed out. People do not know what their rights are. If you do not know what your right is, how on earth are you going to exercise it? So the first question is, make them aware of their right. Make them aware of what the law can give to them, what they can expect from the law. If that is put across to them, widely disseminated in a manner that they understand in fashion that can be put across to them, easily understood by them, then they will be empowered, whether they are women, disabled persons, or persons on account of social stigma, or whatever other difficulty that they have. Then they will be able to say, let's go to the court which is supposed to give us justice. Let us access the temple of justice and see whether this problem that we have, this disability that we have, this pain that is being caused to us can be removed. And that is the role of justice. That is the role of the judges, that is the role of the courts. Interestingly, justice is an abstract noun in the English language. But justice is also personified Justice Manohar. Why? Because she is the embodiment of justice. That is the reason why they are called justice. I do not know how many of us can put our hands on the heart and say we are really justices as understood in law, as understood conceptually and philosophically. If we really are able to give access to justice to the persons who really require it, then administration of justice would have improved in this country. The confidence that citizens have the administration would have improved, and you would have lesser problems to deal with. Now, one of the instruments fashioned in the recent past is the public interest litigation. About public interest litigation, during the World War, some bright doctors came up with penicillin. They said it's a very good, it's Ramban Aushadhi for everything. Now penicillin was so much abused that it became a headache for people to control penicillin-induced problems. So similarly, PIL has been abused so much today that problems created by PIL are required to be sorted out by Supreme Court by various judgments. Number two difficulty with the PIL is that sometimes the courts take on too much which they are unable to handle. I remember as a young lawyer in the Bombay High Court, I was following a case very carefully. The government of Maharashtra, or I don't know whether it is government of India, was importing butter which was radiated in order to see that it doesn't deteriorate fast. They passed gamma rays through that. Now some NGO filed a petition and said, oh, it is radiated butter, that means radiation is there, it is harmful to human beings. The matter came before, by way of a PIL, came before a judge who didn't understand anything, the distinction between radiation and butter itself, basically. So he kept on asking questions which made him, so some wise lawyer got up and said, why don't we ask an expert from the BARC to come and tell us what is radiation, how far it is harmful to human beings, how far it can be taken, and what is the extent of radiation even otherwise in the atmosphere without having to be subjected to a gamma ray source. So this was explained, and then the judge, learned judge, said, this is the problem. Then what is the extent of radiation here? The scientists demonstrated that it is 10 times less than what is harmful to the human being, and that was allowed. This is the problem with the PIL. The judges are not experts in every subject. The judges are unable to handle it. And for example, the 2G case. The questions were asked and said, what is the difference between 2G and 3G and 4G? That's what 2G plus 1G is 3G. 3G plus 1G is 4G. So, ladies and gentlemen, the issue is far more serious than a mere PIL, because the PIL just allows you to walk into the court. After you have walked into the court and put a problem on the table of the judge has to decide it, and if he has not the tools to decide it, if he does not have the administrative capacity to analyze it, if he does not have the ability to implement the decision that he makes, PIL can be Brahma Rakshasa. Our Puranas tell us a number of stories where somebody goes and asks for a simple vara from a god, and having taken it, he will turn out into a Brahma Rakshasa. So, ladies and gentlemen, let's make sure that PIL is used only for the purpose for which it is used, namely giving succor to the lowest stratum of person who deserves it, and not allowing industrialist X to fire across the shoulder of somebody at industrialist Y, which is what is happening today. Thank you very much. It was interesting and enlightening to hear you all. God bless you.
I will begin my vote of thanks by mentioning Bansari Sheth's family. This is the Bansari Sheth Memorial Lecture, and we always have Dr. Sheth and Mrs. Sheth present for it. So I must explain the reason for their absence. Unfortunately, by the time we fixed this date, we were not aware that they were going to be out of the country, and that is why they're not present today. But Dr. Sheth has sent his apologies for not being present, and I thought I should explain that to everyone present, and particularly to you, Justice Sujata Manohar. What can I say about the information we've received today? As a person who is a lay person, I have understood a great deal of the good things that are happening and obviously the shortcomings that are, I suppose, in any system. But if an effort is made to ensure that the best is done within the system, I think then we as citizens of India should feel proud of our judiciary. And Justice Sujata Manohar reminded us that this sense of justice is so deep-rooted, and she gave historical evidence for it, which was then followed up by so many of the observations presented by Justice Sri Krishna. Of course, I missed, I'm afraid I don't understand the Sanskrit, but I was impressed by all the examples you were able to give. So we understand the several dimensions that are available, but the important point I think made is this access to justice, which is imperative. And if that is open to us, I think we should feel at ease that we can approach the courts, and that PILs, as was pointed out, are very, very important as long as they are, as I think you rightly said, the motive is altruistic. The motive is not someone's personal fight that is being carried to the court. I suppose, as I said, every system has its shortcomings, which every attempt, I'm sure, is being made to see that they don't occur, and that justice does reach out to as many people as possible. I think as long as that happens in our country, we should feel safe. I also didn't know that several of these, the PIL has reached other countries in Africa. You gave us important information about that, and the fact that media must also play a positive role, which very often I think does not happen. So I'm sure many of the people present, and particularly students there in such large numbers, I hope you can take back all this information. How much of it you've been able to absorb, I really can't say, but I hope you have made the best of having had this opportunity to listen to someone of the stature of Justice Sujata Manohar. Thank you so much for the effort you have made. Justice Sri Krishna, of course, capped it all, gave us additional information, emphasized the fact that that PILs should not be on flimsy grounds, also reminded us that in everything there are good rulers, good judges, bad judges. But today I think we can safely say that we have made an excellent choice in having a speaker like Sujata Manohar and Justice Sri Krishna to preside. So there are no bads over here today, only good. Meena Vaishampayan, our chairperson of the endowment committee. As usual, she has made the best choice, and I must repeat, as I try to remember to do each time, how very efficiently you deal with the endowment lectures. Thank you so much, Meena. Finally, to all of you, thank you for being present. I'm sure you have benefited, and I hope the students appreciate this opportunity that they have had today. Good night.